Welcome, everybody, to this session, which is called A Crisis in Lawmaking, the Case of Assisted Dying. I have to just say that Mo Lovett cannot be here. She is quite ill, and so I have had to step in as chair. No doubt I will not be up to Mo's standards, and she will tell me about it because I think she'll be listening to this, but I shall try and soldier on. My name is Kevin Ewell, and I head an organization called Humanists Against Assisted Suicide and Euthanasia. And we have a really excellent panel who I will introduce in order of how they're speaking. First of all, we have Simon Calvert, who's a lawyer by training, works at the Christian Institute on many successful campaigns like free speech and family privacy. And he is now very engaged in the whole campaign against assisted suicide or assisted dying that is going on. And second, we will have Hannah Barnes. She is now investigations editor of the New Statesman. That's just changed since she sent in the blurb. She's an award-winning journalist. She was an investigative journalist with the BBC, producing and appearing on the Radio 4 programs like Today. And her book, Time to Think, which was Sunday Times bestseller, was about the collapse of the Tavistock Clinic. And this also won several prizes. And third, we have Lord Daniel Moylan. He's a Conservative peer and opposition spokesman on transport, past deputy chairman of Transport for London. So if you had trouble getting here, there's not anymore. He campaigned for Brexit in 2016, and he is a very active speaker in the House of Lords. And finally, we have Rajiv Shah, who's a special advisor from 2019 to 2024 with the Ministry of Justice, then with the Attorney General's office, and then with number 10 Downing Street. He has a PhD in law from Cambridge, and he has spent the last few years campaigning very strongly against the legislation. And I want to explain that this session has, there's no opposition particularly to the issue. There's no proponents of assisted dying on the panel. And that doesn't mean that you can't speak from the floor and make your opinion, opinion known. We do attempt to get balanced panels, but also the subject of this session is actually much more about the process and much more about the lawmaking. It's been a huge education to me as somebody who's involved in this. I didn't really understand what a private member's bill was at the beginning of it, and now I'm starting to understand the arcane procedures of the House of Lords. And that's what this session really is about. So without further ado, we shall hear from Simon, please.
Well, I just want to use the first 20 seconds of my time to pay tribute to Charlie Kirk, a young Christian man who was assassinated because of his commitment to robust debate. As he often said, when the talking stops, the violence starts, so we have to keep on talking. I've worked on and off with MPs and peers for nearly 30 years. I met lots of amazing people at Westminster, but on the whole, I've watched the quality of statutory drafting and the quality of parliamentary debate get worse. Each generation of politicians, in general, seems to make the previous generation look like giants by comparison. There are, of course, exceptions across the party as people of principle, people who believe in debate, in seeking the truth, in trying to find solutions that really work. But I'm afraid the direction of travel is often more tribalism and more ignorance. Ignorance of parliamentary procedure, ignorance of how the law works. If I hear another MP say that they want to pass this bill to send a message, I'm going to scream, because that's not what legislation is for. That's what social media is for. So these people are often ignorant of how the world works. A lot of MPs who've only ever worked in politics, who've never had to make anything work in the real world, in a media and social media age, the focus can often be more on looking good rather than doing good. And Parliament's noble goal of scrutinising legislation and stress testing it to make sure it works, holding the executive to account, it's disappearing from view, in the Commons at least, with opposition parties and dissenting government backbenchers having fewer and fewer opportunities to actually make a difference. Kim Leadbeater's assisted suicide bill is not the first rubbish private members bill that we've seen, but it's the first one that's been effectively, on suicide at least, it's the first one that's been effectively, though unofficially, adopted by the government. And so it's been able to progress in a way that those other suicide bills weren't, because the government has been able to game the system to help Kim Leadbeater. I can prove that. A PQ was answered in the Lords recently about health and what the government's priorities were, and the answer said that there were a few bills that were priority bills for the government, and one of them was the assisted suicide bill. This is meant to be a private member's bill. And so the minister then said, oh, that was a mistake. No, the mistake was that the civil servant who drafted the answer knew it was a priority, but just didn't get the memo that they weren't meant to tell anyone. BBC Parliament, the Human Rights Commission, the Institute for Government have all questioned the appropriateness of using a private member's bill, pointing out the lack of pre-legislative scrutiny, the lack of things like public consultation and a white paper, and just the lack of time. But all that has been swept under the carpet. So, for example, a government bill, when it gets published, it would come along with a human rights memorandum, a delegated powers memorandum, a legal issues memorandum, an economic impact assessment, an equalities impact assessment. Now, these documents weren't published until months after MPs had started debating the bill. So they didn't have sight of that stuff for most of the time. And that's because this is a bill based on vibes. And when people look past it and look at the detail, they're much less likely to support it. So it's very important to dignity in dying not to give people too much time to think about it. And so 38 pages of the most consequential legislation that most MPs have ever seen, this is the bill, was dropped on them just 2 weeks before they were due to vote on it, without any of those background papers. Kim Leadbeater promised the safest assisted suicide bill in the world with a High Court judge to oversee it. And then that was the bill that MPs voted for in November. But judges told her that that system wasn't workable, so she dropped it. And she replaced it with a panel involving a lawyer, a social worker, and a psychiatrist. But for all the relevance of their expertise in the job, it could just well be an accountant and an architect. And she tried to call this panel Judge Plus. So you take away the judge and it becomes Judge Plus. She used her power as the member in charge of the bill, backed by the government whips, to stack the committee of MPs looking at the bill to ensure a dominant majority for her side. They selected witnesses that were heavily biased, giving opponents no time to table amendments to that list. The Royal College of Psychiatrists, the people who were on these death panels, weren't invited to give evidence until there was a huge backlash for not doing it. There were no elder abuse organisations were invited to give evidence until another witness dropped out. They asked 9 lawyers to give evidence. Not one of them opposed the bill. They brought in 8 overseas witnesses. Not one of them opposed the bill. They had back-to-back Tuesday and Wednesday sittings, giving MPs no time to prepare. They sat later and later into the day. How an MP, without all the resources of the government, is meant to be able to do his or her job. I want to give a shout-out to Rajiv, who worked with Danny Kruger on that committee and did a splendid job. You had oral evidence from 50 witnesses crammed into just 3 days. So the chair of the debate kept saying, time is tight, keep your answers brief, cutting people off mid-sentence. Witnesses would get 10 minutes. Could you disgorge your expertise on a life and death issue in 10 minutes? There was an unprecedented quantity of written evidence, and MPs were getting 400 submissions a week while the committee was sitting. They were not being given any time to read that. The committee rejected 80 safeguards proposed by our side of the debate. The question about whether suicide was going to be free on the NHS, nobody knew until kind of towards the end of the committee when Kim announced it would. And yet during that committee, she referred to the contributions of opposing MPs like Danny Kruger as noise, just noise. So, I mean, the government, as I say, they could have been genuinely neutral on this, and for example, on that committee, allowed not vote. The minister could have not been voting on that committee, but the minister voted with Kim Leadbeater every single time, and the civil service gave him all the arguments to support her position. But like the BBC, pretending to be neutral in order to make his opinion sound more authoritative. I could say more, but let me conclude that by saying that while the House of Lords isn't quite what it was, in my opinion, it's still far and away our best hope of exposing all that's wrong with this bill and making it impossible for Leadbeater and Falconer and the government to proceed with it. The Lords Constitution Committee has made a good start with a highly critical report which says the degree of deliberation, assessment and scrutiny is significantly less than we would expect to see for an equivalent government bill. This is especially concerning given the subject matter. So we look to the House of Lords to ensure that this bill finally gets the scrutiny it deserves, because if they do, it will surely fall apart.
Thank you very much, Simon. Now, Hannah.
Thank you. Just before I share my opening remarks, I just do have to come back on Simon on a few points because they're a bit misleading. Firstly, from my perspective, it is not our side. I don't actually have a principled objection to assisted dying as a concept. But this idea that the government has never supported a private member's bill or that the committee has been stacked against, this is very misleading because the fact is, at second reading, the majority of MPs voted for the bill and therefore the majority of the committee would be in favour of the bill. That is just a fact. It's exactly what happened when abortion laws were changed. I've spoken to Lord Steele, David Steele, about this. And again, the government was supportive of that. So really, there is not a conspiracy going on here. I think, please, can we just remember that? I think it's important. And I'm not going to take swipes at the whole of Parliament and MPs or the BBC, but I just felt it important to say that. So unlike some of the panel, I'm actually not against legalised assisted dying in principle. I don't have objections on the grounds of faith. Morally, ethically, I am genuinely torn, and I'll hold my hands up and say I would probably want it for myself and my family, but that isn't good enough. And it results in bad law because the vulnerable are not protected. So I'm concerned by the timing of this legislation, but mostly I'm worried about this bill in particular, as opposed to any legislation. And I think it lacks detail. It doesn't safeguard the vulnerable. And there has been a real lack of proper scrutiny in the House of Commons. Just briefly on the first point, really, I just don't think that end-of-life care in this country is in a condition yet where people will genuinely have the freedom to choose. I fear that they might be coerced, albeit inadvertently, I think, by the lack of support available. And I've seen how hard and frankly how expensive it is right now to secure a dignified death. I saw this when my own grandmother died last summer. Palliative care is in a desperate state, with the hospice sector's finances in the worst condition they've been in for 20 years. But let me talk about the content of the bill and its passage through Parliament. So in the Commons, a committee of 23 MPs had the task of scrutinising it. The majority had voted in favour at second reading. But I think right from the start, there were concerning moves when you look at who the committee decided to call and not to call, something Simon has touched on. This very early decision not to hear from the Royal College of Psychiatrists was overturned after Naz Shah, the Labour MP, raised some very cogent objections and social media backed her. But it is true that few witnesses were sceptical of the bill. All witnesses from overseas territories which already had legalised assisted dying were in favour. And sometimes, really, their arguments didn't stack up to scrutiny, but the committee didn't always hear this. So I just one example is the Australian witnesses, of which there were 6. In one exchange, MPs asked this witness if she was concerned that, this is a quote, a large proportion of people who opted for assisted dying cited being a burden as their reason. And she replied, this was not the evidence that they had. except it was, because actually official figures for this particular state, I believe it was Western Australia, showed that 35% of those seeking voluntary assisted dying cited being a burden on family, friends or carers as their reason for doing so. Official Australian statistics. And once that was pointed out, the witness responded, and I'm quoting, "If there are people who are saying they are a burden, that does not mean that their decision is not voluntary." A former Attorney General and MP from the state of Victoria actually wrote to the committee after this session, claiming that numerous aspects of his fellow Australians' evidence were factually incorrect or incomplete. Throughout the committee stage, Naz Shah and other committee members, Danny Kruger, they failed to secure further amendments that they believed would strengthen the bill. And it's really worth remembering that while the argument was that these would have made the bill safer in terms of protecting the vulnerable, they wouldn't have undermined the fundamental right, the core of the bill, which was the right for some people to die. So, for example, attempts to introduce a 28-day cooling off period between someone first receiving a terminal diagnosis and any discussion of assisted death didn't go through. Provisions to prevent doctors talking to 16 and 17-year-olds about assisted dying were voted down. Changes that would rule out those with anorexia being eligible for assisted dying were rejected. And attempts to strengthen the bill to protect victims of domestic abuse were also not accepted. And this is where my concern comes in. As Simon's already mentioned, the committee were expected to scrutinise and strengthen this bill without an impact assessment. So they were effectively flying blind. Because how can you legislate for something when you don't know what the impact is going to be? They also had no idea what an assisted dying service would look like or even who would provide it. And neither did all of the MPs that voted through the bill in the Commons. And when that impact assessment was finally published, it was full of holes. It didn't fill in these gaps. What we got was a load of numbers and costs, all hugely imprecise. And to be fair, the document did spell this out in black and white right at the top. It says, monetised impacts are for the most part uncertain with wide ranges attached. It says, significant aspects of the bill that have not been possible to quantify at this stage. Essentially loads and loads of unknowns. Unknown how many staff would be required to operate an assisted dying service, and indeed whether it could be done because there was quite large-scale opposition from key professional groups. We don't know who is likely to take up the opportunity to end their lives. We don't know what drug or cocktail of drugs would be used. So, like much of the bill, that is going to be left to the Secretary of State should the legislation pass. The accompanying equality impact assessment was even worse because it just accepted at face value that the bill did safeguard the vulnerable without interrogating any of the concerns raised by experts. It made no attempt at all at assessing the impact on those most likely to suffer a wrongful death because of this bill. And instead, it talked about the need for information to be translated or for services to be accessible to those with disabilities, and how the bill would quite unbelievably benefit the poor by making assisted dying possible without incurring cost. So this document was framed solely in terms of the question, can everyone access this, rather than will implementing this adversely affect vulnerable groups? So this just isn't how we should make any legislation, let alone legislation that would bring about the most significant change to British society for a generation, something that is literally a matter of life and death. This was lawmaking at its worst, rushed debate, the views of the vulnerable ignored or downplayed, and crucial information on how this bill would actually work absent. And it's been deeply disheartening to hear legitimately held concerns dismissed as noise, or of accusing people of being motivated by a religious faith that they're somehow not willing to be open about. The bill is now in the Lords, where a special committee has been set up to hear evidence from ministers and professionals about those lack of details that remain and how this could possibly work in practice. It is an unprecedented move, but peers have accepted that wherever you stand on the issue, a bill this important deserves greater scrutiny than it was afforded in the Commons. Let's hope they can achieve what so many expect from our mother of all parliaments.
Thank you very much, Hannah. Daniel, please.
Well, I'm opposed to the bill, but in this session I'm going to try to avoid deploying too many arguments about in opposition to the bill, because I think what we really want to focus on in this session is the process. And it seems to me that the sort of the biggest problem with the bill at its heart, process-wise, is that it ostensibly does one thing, but its backers want it to do so much more. Ostensibly, it is about exercising compassion to alleviate pain for people who are inevitably going to die within the foreseeable future. But what it's really trying to do, in my view, is establish the skeleton, the framework for a broad system of voluntary euthanasia. Because if it was simply a matter of relieving of criminal prosecution or the threat of criminal prosecution those who assist a family member to die, then that could actually be a very simple bill. It's a little bit like there's a parallel with the clause in the Crime and Policing Bill that decriminalizes mothers for abortions carried out up to birth. It's one clause, and it hasn't required a huge impact assessment or anything. You don't need a bill for that. And you could do that. You could do what they've been arguing for very, very simply. But the bill is much more elaborate than that because, as I say, I think they see it. This is sort of Dignity in Dying sees this as their one big shot. And what they want to do is put this elaborate framework in place, which can over time, quite rapidly in my view, be expanded to become a full-scale voluntary euthanasia structure, partly because of the inherent contradictions in the bill which are being exposed. Because the more you have contradictions, the more you have cases going for judicial review which say this is discriminatory, this is unfair, this is unreasonable, and then the courts start to expand the scope of the bill, and so you end up with this framework being fleshed out over time as a voluntary euthanasia system. And I suspect that's what's going on that's causing so much a lot of unhappiness about the process. Hannah is, of course, right that the government often does back private members' bills. In fact, the government very often writes private members' bills and then hands them out to people who've come top of the ballot. They're called handout bills. And if you're an MP and you'd like to think, I've got my name on a piece of legislation and I can claim that I passed this piece of legislation, then accepting a handout bill from the government is the best way to do it, because those bills they're normally uncontroversial and they do get passed. And you can claim to your constituents that you're a lawmaker who's actually pushed a bill through. Nothing wrong with that, but that is what very often happens. The principal point I want to make is to defend deliberative scrutiny and discussion in a parliamentary setting as the best means for trying to expose the effects and the consequences and the meaning of legislation. And I actually think that in that context, Parliament, even in the House of Commons, hasn't done too badly so far, because although it is a shamble, I just don't think impact assessments, policies impacts assessment, whatever, I don't think these really ever add very much to anything. They don't reveal a great deal of knowledge. The government very often has no idea what impact its legislation is going to have, but it writes an impact assessment and commissions Deloitte to write something and whatever, but it really very rarely has any real effect. The real means of exposing what the consequences of legislation are, I think, is deliberative debate in a parliamentary setting. And here I come to a distinction between the procedures of the House of Lords and the procedures of the House of Commons. And I frankly admit I don't understand the procedures of the House of Commons. I've never been an MP. And I've learned a great deal too watching this process about how private members' bills are treated in the House of Commons, because it's very different from the way we treat them in the House of Lords. So the fact is, in the House of Commons, the committee stage of the bill is conducted by a committee, by a small number of chosen members of Parliament who have the votes. And other members of Parliament can turn up, sit in the public gallery and watch, but they're not members of the committee. Whereas in the House of Lords, committee stage on every bill will be a committee, effectively a committee of the whole House, where every member of the House of Lords can turn up and speak. In the Commons, the Speaker or the chairman of the committee in this case has great power over which amendments are debated and which are put to a vote, whereas in the Lords, anyone can table an amendment. I've tabled 40 roughly to this bill already. Anyone can table an amendment, and all amendments are debated, although they're very often grouped together by subject, which is sensible to avoid a debate being repeated over and over again. But any member can put down an amendment. Any member can speak to any amendment more than once. And we, funnily enough, we don't vote in committee at all. We never vote in committee. So all those people saying, please, sending messages saying, please vote against this this amendment in committee or vote for this. We won't be voting in committee. We save up our voting for the report stage of the bill when it all comes back, and we can all repeat the process, though normally faster because we've had the debates. We repeat the process in a more focused and faster fashion, and that's when we vote. We vote at the report stage of the bill, but we can vote on any amendment that I can call any amendment for a vote. And normally, it's your own that you decide you're going to divide the House on. But I can theoretically, and I've seen it done, I can divide on somebody else's amendment. If they decide they don't want to call a division on their amendment, I can say I still want to. And we'll have a division and troop through the lobbies and so on in order to divide on that. So it's a very deliberative process where everybody can get involved. It also takes longer and is more open to manipulation in that direction. They perish the thought that anyone would deliberately filibuster, but on a debate as complex as this, you can imagine that there will be quite a lot of time devoted to it. And of course, the bill has to complete all its stages before the end of the parliamentary session, and we don't know when that's going to be, but the government has said now the spring, which is already late. One would have expected this parliamentary session to end in November, but they've extended it to the spring because they're so late on their other legislation. So I just want to explain those differences. However, I would say this: don't put your faith in the House of Lords to stop this bill. I think you can put your faith in the House of Lords to expose further the contradictions and complexities and unresolved issues in the bill, such as, for example, why it should be on the NHS, or indeed why it should be free and paid for by the taxpayer, and things of that sort. But in the end, the House of Lords will defer almost certainly to the wishes of the Commons. And the way to stop it being implemented now, I think it's unlikely the Lords would actually turn it down on third reading. I would vote to turn it down on third reading myself. And the Archbishop of York said he would call a vote on that. But we'll see if he does when we eventually get there. But I don't think the House of Lords would pass such a motion because they will want to defer to the Commons. So there's no way of getting it back into the House of Commons because they finish with it. It'll only go back on detail to the House of Commons. The only way is that it does have a 4-year implementation period. And to hope that as its complexities and contradictions become ever more apparent, that people in the cabinet, or possibly in a future government, that people in the cabinet decide that implementing it needs to be postponed and postponed and postponed, so that it never quite happens. But I don't think you should rely on or even ask the Lords to vote down something that the Commons has said clearly that in principle they want to see happen. Don't expect that. But we might talk it out.
Thank you very much. And last but not least, Rajiv.
Thank you. Thank you very much for having me. So, as Kevin, you said, I used to be a special advisor in the previous Conservative government, and part of my job was getting legislation through. But I've been spending the past year helping MPs in the Commons who have been opposed to this bill. So I can't work out whether I've gone from poacher to gamekeeper or gamekeeper from poacher in the analogy. But what I thought I might do is perhaps talk a bit about an argument I've seen made quite a few times that, well, yes, MPs only saw the document of this bill 2 weeks before, but actually for government bills, sometimes it's dropped on MPs 3 days before. And, there are plenty of government bills that are done without consultation. And so how is that different? How is this, isn't this just the same? And I agree with everything everyone has said so far about the criticisms of the bill, and what I'll try and do is explain how it is actually unprecedented. The main difference with, the government taking shortcuts and perhaps announcing legislation which wasn't in its manifesto, it hasn't consulted on, is that ultimately the government's accountable for it. So we may have our own views on digital ID that the government wants to go forward with. We may have our own views on the legitimacy of doing that when it wasn't a manifesto commitment, but ultimately we have a remedy. We can vote them out of the ballot box at the next general election. And the fact they know that will factor into the calculation of Labour MPs and of the cabinet on, actually, do we really want to do this now that we've seen it's landed not so well? So there is the kind of accountability feedback loop, which is not present at all in this bill. Now, the argument made by Charlie Faulkner and Kim Leadbeater is that, well, it's a conscience issue, and so the government can't stand behind it, and that's nonsense. Same-sex marriage was done by a Conservative government as a conscience bill, even though, and it's still talked about as a great achievement of the Conservatives. Cammy Badenoch in her conference speech spoke about that and cited it, and that is the case even though the majority of Tory MPs actually voted against it. But nonetheless, the government could still make it its own, could still stand behind it, could still be accountable to voters for it. So you can do conscience votes while still being a government bill. There's a more recent example, the bill to ban smoking. That was also a conscience vote, while still being a government bill that the government is accountable for. So that's the sort of first point of difference. It's true, as Lord Moreland said, that you have private members' bills that are drafted by the government. But again, on those, the government owns the policy. It doesn't hide the fact that it is a handout bill by the government. It is open about it. It will say so, and ministers will answer questions and defend the legislation in question. They don't go, oh, it is a matter for the sponsor of the legislation, which is what we've done. Whereas on this one, whenever a government minister is asked about this bill, they can say, private members' bill, ask Kim Leadbeater, we've got nothing to do with it. So there is the real accountability gap that there is on this. The comparisons has also often been made with the abortion legislation in the 1960s. There, I think a key point of difference is there was a lot of pre-consultation prior to the bill being introduced, and all of the key stakeholders were in favor of it. So, the Royal College of Obstetricians and Gynecologists were supportive of it. Most of the medical groups were. The Church of England was supportive. I think the Catholic Church was the only main stakeholder who was opposed to it. Whereas with this bill, none of the key stakeholders are positively in favor. They're either neutral, or neutral with concerns, or opposed either in principle or, as in the case of the Royal College of Psychiatrists, not opposed in principle, but think the safeguards do not work. So there is a real lack of a kind of expert stakeholder consensus on this, which is, again, another point of difference. Then, what was I going to say? Sorry, apologies, that is my son. And so one who very kindly came to see Daddy talk, and heckling because he clearly thinks the standard of the presentation is just so bad. So I can only group orders. So I can only apologize. What was I going to say? Oh, yes. The final point is, as has been said by a few other speakers, this is a skeleton piece of legislation. A lot of the detail which you would expect to see in the bill itself is not there. So, Simon has a copy of the bill, which he can sort of show us. It's only a third of the size of the bills in the Australian states, which are the closest comparators to us in terms of drafting and in terms of, the common law system of government. And the reason for this is because for all of the criticisms we may have of the Australian legislation, they did say on the face of the bill things that needed to be there. So what level of qualification must a doctor have in order to take part in this process? The bill says the Secretary of State will set those by regulations. In Victoria, that is set in their legislation itself in primary. Here, Secretary of State will have to make a decision. The impact assessment tells us the most junior doctors could be involved, but we can't really debate that as a safeguard because it's not there in the bill. And so we don't know that. The criticism that's been made by proponents of the bill is, well, there's 4 years to implement it, whereas in Victoria and Australia, they managed it in 2 years. The reason there's 4 years here is because 2 of those years is not actually implementation on the ground. It's drafting all of the bits that are lacking from the actual bill in question. And so we are very much being asked on an issue of life and death, without any form of consultation beforehand, to vote on something on the promise the details will be sorted out later, without the government being willing to be accountable for this. And that is what's really shocking about this piece of legislation. I think that's it.
Thank you very much.